Good evening to you, ladies and gentlemen of the press. As you're already aware, in the chamber today, we commence the consideration of this so-called tribunal bill. Our contention as minority is that this bill seeks to create a parallel system, an analogous system, unbeknown to the Constitution, if we read all provisions of the Constitution as a whole. It is true that mention is made to tribunal system in our Constitution, but context must be interpreted within the broader scope of Articles 125, 126, and 127. We have a judiciary system. District courts, circuit courts, high courts, court of appeal, and the Supreme Court. If there are issues with the system, the way to go is to reform and to resource, equip, and retool. It is not to create a parallel system with coordinate jurisdiction. Now, if you look critically at the clause 4, which was the subject matter of this long debate, basically, you look at a new adjudicatory body where you say one person presiding as the chair must be a lawyer, but the other two must be non-lawyers. And they are going to preside on criminal matters. We reminded Dr. Ayeni himself, the Attorney General, that when he was in practice as a private practitioner and he dealt with this case of Tagore and Issa Abbas, the Republic versus Tagore and Issa Abbas, he argued forcefully that a judge sitting in a criminal trial must ensure that prosecution lead evidence of probative value proves all essential ingredients of the offense. That was his argument at the Court of Appeal, which was upheld. That to deliver justice is not about chobe or media headline scream. It's not about how the public perception about an individual is, because that can be misleading. Now, what we see in this whole exercise is to create a system where people would be pronounced guilty even before their case is properly determined. No established procedure of ensuring fairness. And it is not only the minority that is complaining. Today, organized labor has come out loudly to re-echo its position on this matter. That we don't need a tribunal system in our country anymore. Tribunal system, we know what happened in the NDC era, where people were targeted, assets were seized, and those people who claimed they were tribunal members enriched themselves. We know that record of the NDC, their predecessor, PNDC. So we, the minority, have left the chamber because the majority leader decided to shut the door. In Parliament, we believe that in all situations of disagreement, there must be a window to discuss, to raise the concerns. But once the majority leader makes a strong pronouncement that whatever the case, they will not listen, they will use their numbers to pass the bill, then there is no point again. Every other effort will be rendered odious. Every other effort by us will be rendered nugatory. You recall that earlier in the day, when we raised this issue, the majority leader, realizing that he didn't have the numbers, immediately called for suspension of the House. So he used the 5 hours to marshal his members into the chamber. Even so, those present were not even up to 115. They were 113. We, the minority, counted them. They were not up to. Yet, those who counted claim that the NDC members were more than that. You are the media. You can get in and do your own check to validate what we are saying. We tell you truth. We will not say anything outside of the truth. So it is clear that the Ethiopia syndrome has set in. They don't want to listen to anybody. And this is for say, Ethiopia. Omu disa choboy, sesebe, asem tu obi, na omu kobo obi kwedua. Omu asise omu party member say, omu kodi nasem. Omu ko sizi nkrofo ejapade, edi nkrofo kotu efiase. Omu endi omu asem ye. Ye nyina ye nyim say ye court system no wo hodada. Ghana no ye wo district court. Ye wo circuit court. Asem ni ye wo da wo high court. High court di wasem so na wo mpenisa wo court of appeal. E wo high court system na mu no ye create specialized courts. Matrimonial causes ye wo ne court wo ho. Financial crime ye wo ne court wo ho. Ye wo commercial court, ye wo land court. Ye wo court a ehwe specific nsɛmsɛmu. Ɛninti no ehun yasa wo si na wo de tribunal a sebi omo betena so so mu di asɛm no. Omo ye lawyers. Wo se ene de emfa ho mo kwakwaye choboy. Inti no sa let the blood flow na ekunkum nkrofo no. NDC for say eno no mo de ba. Yen de ye party MPP yen gina so a ye di PN say sebe amembuo ye de mbra ene ye de yo. And the TUC, organized labor, omusu aye press conference akasa akache omampeni John Dramani Mahama nina ban say sa tribunal no embo Ghana e de anibre ni hawon yawo ni sebi obi mpe wasem a na wakobbo okwedu na obediu etutrosem enti no omunjai ya nuanu NDC for say oh omo de omo nti obia ye kan den sen ye kan sen omo de embra no omo be passe because omo nim dia omo hwehwe yen ya sede ni say politics en yen tokwa ya kire ya adwen yen tumi ntina dem wo a Ghana mbra no omo aye omo adwen so omo mfa ye adwuma enti ne ye pie ye mpie sebe ye sorry ya na ye boycott there bi en sa na tie majority leader nenum asem a okan ye say ye den a ombe pass omuntie yen meaning say organized labor omasem omukan omuntie other civil society ensem omukan ye no omuntie constitutional review committee na kasa no e can be fast our tribunal system and over 15 years and over 16 years our tribunal ye twem dada. In fact, PNDC for more year transition no ferry ntina omo share da keep sa tribunal no constitution. But for a long time, yan for sa tribunal de no enye adwuma. All of a sudden, mo se mo the tribunal bi ba na wo kan embra no kra na judicial council na was sa to me say obe determine san no mo se committee bi ese so omo ebenya oversight. Na sebe Ghana Emma NDC for to me say omonfa embra no enso munsem omon ye de omope ana we ye a form of kangaroo court bia omode ba omode embra e de be back no. We don't recognize such courts. We don't. And someone say, as I said, Ghana 40 years. Reasoner ye di pie reasoner amambuo na ekoso ne gidi se enkoyie na ebia bibi nti ye nuanom NDC for no mo di bibia hyehye omasum omo ntie omo nten soso dia omo fi se omo ye no ene na omo ye sebe ende Ghana no it is munya NDC ni a wonka ho wonya NDC ni a wokasa omo ntie nti no yasemo ane se emprempre se omo aye omo adwen se omo ntie no yen ntena ho na yeni omo enye nkitahudie bi e wo sambra no because omo se omo ntie anu nti na yedi pie.
I move that the entire clause 4 be deleted. Mr. Speaker, my reason is very simple, Mr. Speaker. I would take us to Article 125. Mr. Speaker, Clause 4 refers to Clause 2 of Article 125 and Clause 1 of Article 126. Mr. Speaker, Clause 2 of Article 125 reads, citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor systems. And if you go to 126 Clause 1, Mr. Speaker, what the provision is saying is that because of the provision of such lower courts or tribunals as Parliament may by law establish. So they are rooting that provision from this. Mr. Speaker, let's go to 142 itself. The establishment of regional tribunals have been provided for as the Chief Justice may determine. Mr. Speaker, clearly for many years now, we all know that the justice system that we have in this country has worked. However, Mr. Speaker, the disagreement we may have with certain pronouncements of certain judges. Mr. Speaker, like this morning, my Lord Atuguba, all of us were there when he raised concerns about even certain pronouncements of our courts. Mr. Speaker, that does not mean that we create some parallel structures that we call it a justice system. Mr. Speaker, the provisions in the Constitution were qualified. We cannot be interpreting constitutional provisions in a disjointive manner. Then, in so doing, we create chaos in the system. Mr. Speaker, how on earth do we create a new system to compete with a known system just because somewhere in the Constitution certain pronouncements are made? So we should bring an enactment to govern it. Is that what we are doing? A district tribunal, a regional tribunal, to do what? Mr. Speaker, a tribunal to do what? To compete with the High Court? Or to compete with the Court of Appeal? Or there's going to be a Supreme Tribunal Council? Because if you start this way, what you are going to do is now you are now going to have another Supreme Tribunal Council, which is going to now, you tell us that the Constitution talked about it, so that is also equivalent of a Supreme Court. That is what you are trying to do. Mr. Speaker, I do not think that we need this provision. Mr. Speaker, the entire Clause 4 be deleted. What kind of chaos are we introducing? In the name of reset, you have a district court. You have a circuit court. You have a high court, a court of appeal. You have a judiciary architecture that is not broken. Is it the creation of tribunal system? No. Mr. Speaker, you want a Chobwe court. That is what you want. Where justice delivery cannot be guaranteed. The fact that this provision is there must not lead to any interpretation in isolation. Look at the judicial architecture as a whole. Why would you need a tribunal? The Constitution is telling Parliament to make a determination. The Constitution says Parliament, as Parliament may determine. Mr. Speaker, and I'm saying that this Parliament must know that the justice architecture we have is not a broken architecture. It's not. We have a district court. We have a circuit court. We have a high court. We have a court of appeal and the Supreme Court. All these years, we know that during the transition into democracy, there existed some populist justice system which found its way into the Constitution. Is the reason why the framers of the Constitution, they have never imposed anything, so nobody should take solace in the Constitution and say that it is in the Constitution. No. They say Parliament may. Because, Mr. Speaker, we have to be careful creating an analogous justice system. We have to be careful. Because, Mr. Speaker, it leads to some uncertainty. Now you are bringing a whole legislation for this, Mr. Speaker. Instead of improving on the structures and resourcing the courts, help the court to be fully digitalized, help the court to have the necessary tools to administer justice. Then you say you are creating another bureaucracy to bring a new tribunal. Mr. Speaker, we know of what the tribunals did. The dark days of Ghana. We are revisiting it on Ghanaians in this democracy? No. Mr. Speaker, the Attorney General himself is a human rights practitioner. We know his record at the court. A respected human rights lawyer. He is introducing this tribunal system that is going to destroy the justice delivery system. Mr. Speaker, we have to be careful. Is it going to be in charge of civil matters or criminal matters? Mr. Speaker, I am asking rhetorically. I contend that creating this new tribunal system by this provision, Mr. Speaker, will bring chaos to the justice delivery system we have in our country. Mr. Speaker, this is populism. We need clarity. Justice must not just be done, must be seen to be done. Mr. Speaker, I remember the famous case of Tagore and Issa Abbas, where the respected Dr. Dominic Ayeni took the matter up at Court of Appeal. These were individuals who were convicted. And at the Court of Appeal, his argument was that a man may not just be convicted because of his own words. That is populism. He argued. He said every element of a crime must be proven. Lead evidence of probative value. That was the argument of the respected Dr. Ayeni. It was because we had a clarity, certainty in the law. We had a Court of Appeal, well properly constituted. Today, you want to have a tribunal? A tribunal. Populism, Chobwe justice. Chobwe justice. Mr. Speaker, Chobwe justice, where people will be sent and people will be thrown into jail. Mr. Speaker, I will not sit here as a minority leader and allow this provision to stand. I move that this provision be deleted